was worried about time limits.
Okay. Good. I mean, it works out for both of us.
Okay, 10 seconds, roughly. 10, 9, 8, 7, 6, 5, 4, 3.
This is Speak Up. I am Sandra Schulte. Welcome back to our show. I am so delighted that Kenneth Jacobs of Smith, Buss, and Jacobs, or rather Buss, Smith, and Jacobs, was
No,
able to come back.
Smith, Buss, and Jacobs.
Thank you. Is able to come back with us. Today he's going to talk about the effect of a new law that was passed recently in the Senate and the House that affects Westchester and Suffolk counties. He's also going to talk about some other things that I think our audience in New York City and New York State ought to be aware of. Kenneth, I thank you so much for coming back.
My pleasure. Okay. Let me clarify a couple of things. The laws that were changed, these laws, the Suffolk County law
Yes.
has been in effect for a few years. The Westchester County law was passed by the Westchester legislature.
Not by New York State.
Not by New York State. It only
Oh.
applies to Westchester.
Mhm.
All right. But as I may get into later, both of these laws are what I'll call the canary in the coal mine,
Go on.
because similar laws have been introduced in both New York State, the Assembly and the Senate, and in the New York City Council for years now.
Mm-hmm.
They've never been passed, but when you hear about the laws, then you'll understand why they're of concern to co-ops. Okay, I'm going to talk about the Westchester law
Yes.
first. Okay, it's the new law has several parts of it. The fundamental change is that if a co-op board does not, it sets time limits for when a co-op board has to acknowledge receipt of the purchase application and then review the purchase application and then decide whether to accept or reject the prospective purchaser. If the board rejects the prospective purchaser, it not only has to give the reasons why it has rejected the prospective purchaser, but it also has to report the rejection to the Westchester Human Rights Commission. Why the Westchester Human Rights Commission? There is anecdotal evidence, and I want to stress this, and I'll be frank, my bias is toward the boards. There is anecdotal evidence only that purchasers feel they've been discriminated against when they've submitted their purchase applications. I want to emphasize, and I'm editorializing here, that purchasers have always had the right to go to the Westchester Human Rights Commission if they felt discriminated against. And the Westchester Human Rights Commission, under existing fair housing laws, has always had the right to investigate a claim of discrimination.
What kinds of discrimination do they consider discrimination?
Well, if the purchaser is a protected class, good question. So if the purchaser feels they've been discriminated against on the grounds of race, religion, national origin, disability, family status, sexual orientation, I could go on, but those basically are nowadays the protected classes.
But wouldn't that apply to New York City too?
Yes, but New York City hasn't passed the express law.
Okay.
But let me tell you, when somebody feels that they've been discriminated against, they have no problem going down to the New York City Human Rights Commission, filing a complaint, and the Human Rights Commission will investigate it. That's why I think a law that requires this to be reported to a rejection be reported to the Human Rights Commission is unnecessary.
Well,
Nevertheless, we have it.
I think that I was discriminated against because I wore a flashy lipstick and my husband came with a cap facing backwards.
Okay. In theory, everybody hears the stories about how co-op corporations, they're so picky, they can reject you arbitrarily for wearing your cap backwards, etc. That may apply to the Gold Coast co-op corporations, where the club where you have to have a certain triple your net worth or triple your liquid assets in net worth, or something where belonging to the exclusive club really applies. But what I have found is that
Yes.
99% of co-op applications, applicants have been rejected on financial grounds. You know, if you're in a typical co-op corporation, the co-op doesn't really care about how you wear your cap. They do care about whether you can pay your maintenance charges. So, as I said, this is anecdotal evidence. There have been very few, I am aware, and my firm represents 350 co-op corporations. We represent Co-op City, okay? So that's a pretty good sample size for potential discrimination claims. And we are aware, very few examples of discrimination on a
York
protected
City
class.
would not be the gilded avenues of Manhattan.
No, it's not. And I will agree that in the past, 40 years ago, there might have been complaints about it, but not since we've been representing
I
them. We have not, basically, forget Co-op City. Let's take the typical 100-unit co-op corporation, all right? Middle class, not Fifth Avenue, not Park Avenue. We have not seen rejections except on the basis of financial ability. So I believe that the Westchester law is unnecessary. Nevertheless, it's passed.
Yes.
So that means the co-op corporation has to report its reasons for rejecting an applicant. Now, in addition, in order to demystify the process, the co-op corporation has to state if it has financial standards. So if the corporation has set financial minimums or a specific loan to value ratio or debt service coverage ratio, getting too complicated here. If they say that your maintenance can't exceed more than a certain percentage of your income, or your maintenance plus mortgage can't exceed a certain percentage, you have to publish that so that people know it. Even if the co-op has ranges, all right, if the co-op says, well, we don't have a set guideline, but we like people to be within a certain range or meet a certain minimum, you have to say that. You have to say that this co-op corporation prefers that an applicant have minimum income, or its income be 3 times, the monthly income be 3 times the monthly maintenance plus the mortgage. It's a preference. You have to say that. You have to let people know. So it does demystify the process somewhat.
You can't just say, we have the right to choose who's going to ride our elevators, and we just don't like the applicant.
If that's your, if you have if you don't have a financial standard, then you could say that. But if you do have a financial standard, or you have a financial preference, and most co-ops do, all right, this law requires you to let applicants know where you stand. There is discretion on the part of the board. Now, one concern that people have is, well, we have to give the reasons. What if the applicant disagrees with our reasons? What if we write down, we didn't like, the applicant was rude and self-centered during the interview. We didn't think that they would be a good member of the community. And
What if they just say, we didn't like her?
or we
Or
didn't
him.
like them, all right?
Period.
Okay. I'm going to repeat. I have rarely seen that from most of the co-ops we represent. And we do represent some number of Park Avenue and Fifth Avenue co-ops too. All right, we still don't see it in that. But even so, the co-op corporation is governed by what's called the business judgment rule. And what that means is that the court is not going to look over the shoulder of the co-op board in deciding whether the co-op board had the right to reject the applicant. As long as the co-op board is acting in good faith and doesn't violate civil rights laws, the court is not going to say, I don't like your reason for rejecting the applicant. I'm overruling this. It will allow the co-op's business judgment to prevail. Okay? The Human Rights Commission, it's the same thing with the Human Rights Commission. If the co-op had a justification for rejecting the applicant, now the Human Rights Commission, they're governed by a different law, and they could say, we think that your rejection was a pretext, and then you argue it out in court whether or not it was a pretext and that this person was actually in a protected class and was discriminated against. But the co-op can exercise its business judgment. Now, the co-op doesn't always have the right to exercise business judgment. The next standard up is called the reasonableness standard. Okay.
What if the proprietary leases has reasonable in this clause, and that clause, and the other clause, but doesn't have reasonable in a few other clauses?
Well, okay. For purchases and sales, usually the proprietary lease or occupancy agreement says there shall be no limitation on the discretion of the co-op board to accept or reject an application. What's implied is as long as it doesn't violate civil rights laws. So that's business judgment. But sometimes it says the board, in the same section, purchases and sales, it says the board cannot, usually it says the board cannot unreasonably withhold consent to the transfer of an apartment to a financially responsible heir. If the shareholder dies, the co-op cannot unreasonably withhold consent to the inheritance of the apartment to a financially responsible shareholder. We've actually litigated this because a co-op board exercised its business judgment. They didn't like the heir. He was living in the apartment. They thought he was weird. So they refused to allow the transfer of the apartment to the heir and his brother, who happened to be a doctor. Okay? We litigated this up to the Court of Appeals, which is the highest court in the state, and the Court of Appeals said, no, you have to apply the reasonableness standard. Was it reasonable for the co-op board to refuse to consent to the transfer to the doctor and his brother, the weird guy? All right, and the answer that the court found was no, it wasn't. So they permitted the transfer. Okay, so that's the difference. When you have the reasonableness standard, the court can look over your shoulder and decide whether what your action was reasonable, whether a typical person would tend to agree, this mythical person sitting back would tend to agree with the co-op board's decision or your decision. Were they reasonable? Was their consent to alterations reasonable? Was the house rule that they passed, which happens to have an extraordinary impact on you, reasonable? Was this transfer reasonable? That's where it comes up typically.
Well, it's really a conundrum because they could say, hey,
Yeah.
business judgment is
It's complicated. But I want to emphasize the Westchester housing law that was passed
Right.
still allows the board to exercise its business judgment, but the Human Rights Commission can say, did you have a reasonable grounds, or was this a protected class, and therefore you unreasonably rejected them, and we're going to find you liable. Now, the Suffolk County law, which has been in effect for a couple of years, also requires the co-op board to give its reasons for rejection. It does not require you to report your reasons for rejection to the Suffolk County Human Rights Commission. But as I said before, it doesn't matter, because if somebody complains to the Human Rights Commission, they have the right to investigate anyway. I want to mention one good thing about the Westchester law, and that is that it requires that co-op boards get training, regular training. People get elected to a co-op board and they do not realize how much work is involved in actually running a building.
Not only that, they don't realize that the rules of the road. The rules of the road are, the proprietary lease. They don't familiarize themselves with a proprietary lease. And the bylaws, they don't familiarize themselves with the bylaws.
Right. They've just read the articles that says the co-op board can do whatever it wants, and they think that they become dictators, and they don't realize that there are rules that they have to abide, and that the proprietary lease imposes obligations on them as well as rights.
But they figure, hey, this is judgment. We're right whether we're right or wrong.
Right, correct. So the training that the Westchester law, actually the training ends up getting focused on fair housing training and what's discrimination and what's not.
Yes.
And maybe I got a little too enthusiastic here because I believe that all boards should get some kind of board training. And as a matter of fact, a law that was passed by the state recently requires Mitchell Lamas and other limited equity co-ops to get board training, and it requires DHCR, requires the Division of Housing and Community Renewal to promulgate a curriculum for board training every year on the theory, their theory, if you think about it, they're discriminating against shareholders. Their theory is that these shareholders just aren't sophisticated enough to understand how to run a building. So we need the HCR to give them training. It's not, that lack of sophistication is not limited to limited equity housing shareholders, trust me. All boards would benefit from understanding how to run the business and protecting their investment. So anyway, it's good that the Westchester law does require fair housing training, and that should ultimately lead into a broader training. There are a lot of organizations that provide this training. Council of New York Cooperatives does. Community Associations Institute, which is a national organization, provides this training. And so I recommend that boards go there. I'm going to segue, or maybe you want to.
Go ahead.
You can segue. Okay. All right. There's another recent change that does not. It's not a fair housing change. It's not a Human Rights Commission change. It's has subtler differences, and that is the legalization of marijuana in New York State, the decriminalization of smoking marijuana in New York State.
Yes.
We've gotten a number of questions from people on what did they have to watch out for as a result. There's two parts to this. First is the impact on other shareholders or condominium unit owners in the building, okay? There's a myth that if you own a condo, you can do whatever you want. Not unlike a co-op where they monitor your every move, all right? Not true. On a day-to-day basis, condos and co-ops operate the same. So what I'm telling you now is operating both, it applies to both co-ops and condos. Marijuana, there's a typical house rule that says you can't, you cannot do something which causes unreasonable odors to emanate from your apartment. So just like cigarette smoke and secondhand cigarette smoke can be a nuisance to other owners, so can marijuana. The odors of marijuana be a nuisance to other owners. A lot of my buildings have proposed prohibiting smoking within apartments as well as in the common areas. New York City prohibits
Then
that.
the person whose apartment it's coming from says, oh, it wasn't marijuana, it was perfume, it was who knows what.
Well, first of all, usually you're going to get multiple shareholders or unit owners corroborating whether or not this has been a problem. Because the idea is to get independent corroboration to allow this to go forward. Second, marijuana has carcinogens also, the same as secondhand smoke. And those buildings that have considered barring smoking throughout the building, including within units, have included marijuana or any other plant-based substance. And if your perfume is that strong, I mean, my son puts on Axe like it's like there's no tomorrow. If it emanates into another apartment, I'll talk to him about it. But the point being that just because marijuana is legalized doesn't mean that the odor might not be obnoxious to other people, and doesn't mean that the co-op or condo doesn't have the right to regulate. It does.
So basically, you could do it in the street, that's okay.
Yeah,
But once you go walk through that door,
right,
it's a different story.
right. That's okay. The other impact is on employees. All right. A lot of people haven't considered this, but now that marijuana has been decriminalized, you have to. If an employee smokes marijuana, you think they're smoking marijuana, you have to treat it more like alcohol. You can't automatically say you're violating the law, I'm discharging you. You could test the employee, but if the employee's performance is not going to be impaired based on what he does, what his duties are, then your ability to regulate his behavior is going to be much more limited.
It's very difficult because you see the person, you maybe even capture him wibble wobbling on camera, but how do you capture his level of marijuana
Right.
at the same time?
You can't. Well, right. You can't
can't
test the
cooperate.
same way. Exactly. Like you could do a breathalyzer test for alcohol. All
If
right.
you're there within a certain amount of time.
Right. Marijuana lasts for a longer time. He could say, I don't do it when I work. I do it at home. It creates many more complications for the employer. But I think the test really is this going to impair how he performs his duties? A lot of people say that marijuana doesn't impair their ability to function the same way drinking too much does. And you have to make that evaluation. Is this person a lifeguard at the pool? Are they a doorman? Do you want to have that marijuana odors wafting out to all the visitors to the building? Or are they a porter who collects the garbage? So this is going to create some more complications for employers. And the union is certainly endorsing allowing a lot more flexibility for workers. They're not coming down on the side of if you're caught smoking marijuana, you're immediately discharged. So be aware of that. At this point, the only other change that I'd like to address,
Yes.
if we have the time,
Please.
is reasonable accommodations. Now, this law was passed back in March, but it's something that applies to unit owners, individual unit owners, and individual shareholders who are leasing and subleasing their apartments, as well as to co-ops and condos.
It's very important because we all reach a certain age. And when we think at age 30 that we can rule the world, we get to be age 80. That's a different story.
I know. We feel a lot more vulnerable as we get older. It's true.
There are more people with
disability-
leg problems, back problems,
Right,
eyesight problems.
right. So you can't be discriminated against, and you do have certain rights to reasonable accommodations if you become disabled. And a headache, by the way, is not a disability, all right? Smoking, being addicted to smoking, cigarettes, is not a disability, all right? But you can imagine what is a disability. Blindness, a permanent impairment that's going to impact, or semi-permanent impairment that's going to significantly impact your quality of life. You're entitled to certain physical accommodations on the part of the building in order to address your concerns. So for somebody in a wheelchair, that might be putting in a ramp. All right. Probably everyone says, well, I know this has been around forever. But now you have this change in the law requires a notice to be put into the proprietary lease and to be put into leases or subleases, telling tenants that they do have these rights. So it's more paper that comes out now. This is in addition to the window guard rider, the lead paint testing rider, There's one for, there's one requiring checking stove covers, the knobs on stove tops. If you're a non-resident shareholder, you have to pay special attention to stove tops. Anyway, it's more paperwork, it's more notices, and be aware of this if you are a shareholder or a unit owner.
At what level can a board reject an applicant because they have a physical disability?
Well, you can't reject somebody because they have a physical disability. You can't. Now I'm going to get into emotional support pets, but all right. But if you consider, let's say you have an anxiety. Well, as far as the physical disability is concerned, if
Let's say you walk with a cane, or you have a leg problem of some kind.
You have a leg problem. Or you're blind. Okay, you could require that if the building has an elevator, that the elevator have certain sound cues in order to allow you to know when you're getting off a particular floor. Or if you have leg issue, if you're in a wheelchair and there are steps in the building, all right, the building might be required to put in a lift, so you could roll into the lift, go up the steps, and then go into the front door and have an automatic opening front door. So if you're in a wheelchair and you can't open the door.
But the board has not listed that as the reason for your rejection as an applicant.
No, but if you're rejected, okay, well, again, if the board says we're rejecting you, in Westchester, they have to give the reasons. So if they say we're rejecting you because your finances aren't adequate, or we don't believe that you're really intending to live here,
Yes.
we think you're going to turn it into an investor apartment, and you think it's a pretext, you complain to the Human Rights Commission, and you roll in your wheelchair and you say, I think I was rejected, here are my finances, I think they're fine. I think I was rejected because I'm disabled and the board did not want to spend the money to put in a wheelchair lift or automatic opening doors.
Kenneth, what would you like our audience to take away with them? Training is wonderful.
Yeah, training is wonderful. Training is wonderful, okay? I believe that most of the listeners here are aware that they can't discriminate against buyers. And they're aware, and if you're not aware now, trust me, as you get older, you might be put into a wheelchair. So what you might dismiss now may not be the same in 20, 25 years. And especially in co-ops, a lot of people are aging in place. So the co-op corporations need to be prepared to make more accommodations to deal with a population that's more likely to need them. You really should plan ahead in your budget for reasonable accommodations, and of course, don't discriminate against prospective purchasers. Look at their finances first and primarily. That's my takeaway on this. And consult your lawyer if you have.
Consult a lawyer.
Consult your lawyer if you have any questions. We're here for you. We're a resource.
Ken, thank you so much for coming back and giving us this presentation for my show. This is Sandra Schulte. Until next time, have a wonderful, wonderful rest of the day. Goodbye.